Maybe to mention it, I'm going to mention two items to be listed in view of can be disposed of on Friday in view of the Supreme Court judgment, Your Lordship. Case is in my favor. That two writ petition may can be disposed of in view of the Supreme Court judgment. That is a payment of gratuity act. Supreme Court several writ petition has been filed by Assam Financial Corporation that has been dismissed and single judge order and division bench order of the High Court sustained. Friday. It's Monday, Your Lordship. Yes.
Well, please, Your Lordship. Lordship, in item number 9.
Yes, Lordship. Today I am giving it.
Lordship, in item
My lord, I filed a writ petition, my lord, challenging the departmental proceeding, my pension, everything got hold up, my lord. So it has not been listed, my lord. For Monsoon, I filed, my lord, on 3rd. So can it be tomorrow, my lord? My lord, yes, my lord. Yes. My lord.
Lordship, in item number 19, we have filed an
Yeah.
affidavit in opposition today. May that be called for, Lordship. Item number 19 was supplementary list, Your Lordship. 19. Filed today. We are filing it today. Today. Obliged, Lord.
My lord, I beg to mention for listing, my lord.
No, Lordship. We were informed that we'll call that for the affidavit. The petitioner is here, Lordship. Mr. D.N. Bhattacharya.
Well, Monday.
Obliged, Lordship.
My lord, I beg to mention for listing, 1IA, my lord. My lord, the petitioner, my lord, discharged from service, my lord. He approached before his honorable court, my lord, filed, my lord, writ petition, my lord. My lord, what happened, my lord, in the subsequent, in the pending the writ petition, my lord, there was, my lord, the subsequent development, my lord. Where, my lord, petitioner, my lord, with due permission, my lord, appeared, my lord, one, my lord, post, my lord, sub-inspector, conducted by, my lord, the staff selection commission, my lord. My lord, he selected my appointment has been issued, my lord, appointment letter. But there was one condition, my lord, subject to, my lord, no objection certificate or discharge certificate from the previous employer, my lord. And my lord, report to join, my lord, 22nd for my discharge of, from service, my lord. Yes, my lord. He was, my lord, originally, my lord, in IFI, my lord. He during pendency, my lord, he selected, my lord, one, my lord, conducted by SSC, my lord, in sub-inspector post, my lord. And now, my lord, the appointment letter has been issued. My lord, one, my lord, condition is there, my lord, no objection certificate from, my lord, the previous employer, my lord. That is why, my lord, my lord, that on tomorrow, my lord, tomorrow, Thursday, my lord. Thursday, my lord. Next to my 22nd, 11 is the last date, my lord, to report, my lord. My lord, Friday, my lord, then. Fine. Obliged.
May it please, my lord, prayer for listing of an admission matter. My lord, my lord, I'm a, my lord, my lord, a worker in a Anganwadi center. My lord, may I kindly, my lord. My lord, the urgency is that this honorable court has protected my services through an interim order. But the problem is I was rendering my service since 2018, but till date my honorarium has not been paid and that has been admitted by the respondent authorities on my lord.
May it please, your lordship. Lordship, I beg to mention item 4 of today's list, your lordship. I have informed Shri S4. I have informed Shri SAKR, Dr. Ashok Sharaf is leading us in this matter, your lordship. Yes. R. Sharma. 18, your lordship, if not. The Parthat matter. Lordship, after
Then after-
10th of December. 10th of December after. 11th, 11 for 11 of December, 11 for. Then
11, Lord.
11, then 16, let it be on 16 then. Twenty-seven. 27, 11, you can get 11. Much obliged.
Yeah, please, your lordship.
Obliged.
Lordship, I beg to mention for listing on writ petition, lordship. This writ petition was last listed on 5/6/2025, and the matter pertains to this writ petition is, lordship, non-payment of subsistence allowance, lordship. Any day in the next week, lordship. 19th. Lordship, another writ petition. Another prayer, lordship, this writ petition was last listed in the year 2022, lordship. Thereafter, not listed because. 20, highly obvious.
Please, your lordship, I beg to mention listing of an WBC. Lordship, the matter related to disqualification of the petitioner on the ground of height. Lordship, 14 Friday. Lordship, obliged.
Lordship, I beg to mention our matter for listing a WPC. Lordship, the matter was last listed on 30/04/2020. Obliged.
Obliged.
May I please, your lordship, my lord? My senior is out of station, my lord. Kindly matter can be taken after tomorrow, my lord.
Your lordship, I have an objection for that prayer because your lordship, they are on interim protection and they are praying time after time, your lordship.
My senior is out. We have already informed yesterday to him, my lord. My
Your lordship, the issue is like this. They are A&M nurses. Now they have came up before this honorable court saying that their names are not included in the gradation list. And
yes, my lord. Yes, I have been.
your lordship, the understanding was that the matter will be taken up today. They agreed to it, your lordship. Unnecessary 140 posts are being kept at abeyance, your lordship. They are only 14 in numbers. Then let it be modified to that extent. I am praying that if the matter.
No, Lordship.
No. No, the issue is like this. We are before your lordship because of that reason that we are the persons who should be promoted to that post. Now, because of this stay order, because of the operation of the stay order. No, because of the stay orders, your lordship. And the stay orders is that your lordship will kindly look at my, it's in the,
Direct produce the records, Lordship. I have not yet received the records, Lordship. So let the matter come after tomorrow.
your lordship, the records are not required from the pleadings of the petition itself. It is proved that they are enjoying a stay order which they are not entitled to. Your lordship will kindly come to page 37 of my IA. 3068 আছে এইটো তাতে আছে প্ৰথমতে দিছে এইটো। In fact, your lordship, there is no provisional list at all. The list which they have annexed were already cancelled. Now, in the guise of these interim orders. No. Your lordship, those two lists were published in 2024. Those were cancelled. And in the guise of these orders, the department is not promoting your lordship. So they, from their own facts, admitted that there are 14 in numbers. 140 post has been blocked, your lordship. These are the nursing personals. These are a public interest post, your lordship. The nursing schools as well as the hospitals request the persons.
Yes, my lord.
May I pray, your lordship, in that case, it can be taken up at the top of the list.
Yes, my lord.
The only thing, your lordship, on 18th, your lordship will take up it for final disposal. But in this, today, what I'm praying for is that there are 14 in numbers. Let that be modified to that extent, your lordship.
Hearing that one.
I'm not to say. Your lordship, they'll not agree because the reason is that I'm saying, your lordship, now for 14%. Yes, your lordship. What I'm trying to project is that for 14 numbers of person, can 140 posts be blocked, your lordship?
हाँ जी, आप लोग मानो।
Yes, your lordship.
हाँ जी, आप लोग।
Keep level, your lordship.
May it please your lordship. My lord, petitioner was enrolled in Assam Rifle in the year 1977, my lord. And in the year 1980, he has completed almost 5 years of service, my lord. One day morning when he was going for PT parade, my lord, he fell down. He was hospitalized, my lord. Later on, it was detected that he was suffering from idiopathic epilepsy. And thereafter, they have suddenly discharged the petitioner. Yes, my lord. Complete.
Lordship, the matter may be passed over for the time being. The learned at KG is appearing in this matter. He is on legs in court number 1. Okay.
Yes, lordship.
It pleases my lord. My lord, sorry for interruption, my lord. Counsel Mr. B. Gogoi is occupied in court number 19, my lord. He is going to appear for this matter, my lord. My lord.
Lordship, this matter relates with the petitioner number 2. Petitioner number 1 already been appointed during pendency of the matter. So matter relates with only petitioner number 2. Yes, given this lordship to promotion to the grade post, grade 3 post from the beyond lordship. So lordship, so against our plea, the respondent number 2 has filed their affidavit in opposition. I am referring their opposition, page 25, Lordship, para 4. Page 25. I am reading the para 4, Lordship. That with regard to the statement made in para 6 of the writ petition, the deponent has no comments to offer so far as some are borne out of the record. However, anything beyond the record are denied and disputed by the answering deponent. The deponent Pata Baxi stated that there were 11 vacancies in the cadre of junior assistant in the office of Assistant Commissioner Dhuri unit. However, in the cadre of grade 4, there were only 5 staffs, out of which one was deputed in other office. As such, promotion of the petitioners were not considered at the point of time, as because promotion of the petitioner to the higher post will result in shortage of the staff in the grade cadre of grade 4, and it will affect the smooth functioning of the officer. It was factually not correct, Lordship. Lordship, against their opposition, we have filed reply, Lordship, affidavit reply, where we have stated, I am referring the page 31 of affidavit in reply. I'm reading for page 31 and where is second paragraph. Whereas in case of not entertaining the promotion of the answering deponent from the post of grade 4 to grade 3 in the office of Assistant Commissioner Dhuri unit, the respondent number 2 in paragraph 4 affidavit in opposition has stated that as per service rule that only 10% of the vacancy of junior assistant can be filled up from the grade 4 by promotion. As a result, promotion of the answering deponent could not be considered. If so, then how the 6 numbers of grade 4 in the cadre of junior assistant when promoted against the total 6 number of vacancy in the same office of the respondent authority, which used to be crossed 10%, and as total 6 number of promotion has been done against number of vacancy, and 17% was done as per the statement. The ministerial rule, Lordship. Lordship. Assistant Commissioner. Ministerial Lordship. Ministerial Staffs Rules, Office under the Commissioner of Taxes. Most probably, Lordship, it was not. Rule has not been mentioned here, Lordship.
My lord. My lord, district ministerial rules, so far as my knowledge goes. my lord.
Lordship, let me control. I need some time to.
Thank you, please, my lord.
My lord, we are supposed to produce the bring on the record, my lord. We are supposed to bring the records, my lord.
So may kindly see the last order.
authority, my lord.
Order dated 16th of October. They are supposed to get the record regarding the departmental proceedings
My lord.
initiated against the.
My lord, we are receiving it today, my lord. I'm informed, my lord. It's coming, my lord, on the way. So we'll be receiving it, my lord, today. So, my lord, Huh? So, my lord, once we receive the record, my lord, we'll go through it, my lord. We'll place it, my lord. My lord may fix next week any date, my lord.
The discharge order, Lordship will get the order at page. Discharge order annexure 5, page 27. Last page, 27th of July 2023. What happened here? So cause notice issued on 24th of July 2023. They are giving 10 days time. So before expiry of the 10 days time to file reply, the authority has issued this impugn order. My respectful submission is that this discharge order is stigmatic in nature and punitive, because the allegation is based on the misconduct. So when the law says, when the allegation is based on misconduct, the principles of natural justice have to be followed. So last question I also submitted relying on 2 judgments also. It clearly reflected also. So that is why Lordship directed him to get the record. On the face of the document, or it's clearly, it reflect that. So cause notice issued. So cause notice Lordship find it annexure 4, page 24. Because I have been informed that before submitting the reply, Lordship kindly have the annexure 4, page 24. This is the so caused on 24th July. Within 10 days, Lordship. No. From the date of issuance of the so cause notice, they have issued the impugn order immediately after 3 days, on 27th. Yes. Although they have given that your explanation is required to file within 10 days.
Yes. My lord. Yes, madam. My lord, next week, my lord.
Even other also, Lord, from the face of the record, this order is punitive, Lords. Lords. On a hearing day, Lords. Next Thursday, on 28th, if it is not inconvenient, Lords. 28th of November. Sorry, the 27th of November. Lordship. 27. Obliged. My lord, the other day your lordship directed us to produce a ruling. I have sent it, it is coming shortly. For Xerox which has gone. Now I am submitting only the factual points of the case file. My lord may kindly see the appointment letter of the present petitioner as staff nurse, page 12. Operative portion, page 14 and 15. No, that was directed but that was not filed by us. But some persons filed a case on the basis of that, those persons were promoted. I am seeking the benefit like Meera Basho, because both of us were appointed on the same day as staff nurse. Kindly see page 14. It starts from page 12. Page 12, kindly see page 12 first.
the page 12, subject to discharge without notice and assigning any reason thereof, and subject to the satisfactory PVR, the following qualified GNM candidates are in the interest of public service hereby appointed temporarily as staff nurse. So this is the order dated 26/9/91. Now, Lordship, kindly come to page 14. Here, serial number 24 is Miss Khairun Nisa Mozumdar. And Lordship, now kindly come to page 15. Serial number 29, Miss Mira Suikia. So, on the same day, we were promoted, and my serial number was 24 and her serial number was 29. But unfortunately, my lord, yes, it is appointed. Thereafter, my lord, I joined and she also joined, and thereafter, Mira Suikia was promoted as ward sister. Page 16, Lordship, kindly see. 16. No, sorry, it is my promotion order. Page 16, my promotion order as ward sister, page 16. Serial number 8. It is 8/11/19. Lordship has seen? 8/11/19, I was promoted as a staff ward sister. I joined there. Now, Lordship, kindly see page 21. This is the this is the order your Lordship other day quoted, that in pursuance of the judgment of the Honorable Guwahati High Court, order dated so-and-so, and number so-and-so, in WBC number so-and-so, and as per recommendation of the promotion committee, subject to the reversion without notice and without assigning any reason thereof, and until further order, the following senior ward sister, ward in charge sister tutor, PHN, are hereby temporarily promoted to the higher post of assistant matron. Now, assistant matron, Lordship, kindly see page 22, serial number 29, Mira Suikia. She has been promoted as assistant matron, but I was not promoted. I was not promoted. I am not against Mira Suikia, but this is my clear case. My prayer is that when Mira Suikia was appointed as assistant matron, I was not promoted. So from that day, my promotion should be treated as assistant matron. Then again, Lordship, kindly see page 28. Page 28. This is the order, Lordship would see. I have been appointed as assistant matron, and my name is serial number 40, page 29. Page 29. So 40, that means I have been promoted as assistant matron on 7/9/23, whereas Mira Suikia was appointed as assistant matron on 8/11/19. Eight and one, page 16, Lordship. Page 16. No, it is my promotion, yes. She was promoted 1/12/21, and I have been promoted on 7/9/23. And thereafter, Lordship, kindly see, I have been promoted as assistant matron only on 7/9/23. And my regulation order, Lordship may kindly see page 32. The services of Srimati Khairunnisa Muzumdar, staff nurse who were provisionally appointed by this directorate order number so and so dated 26/9/91 is hereby regularized with effect from the date of her joining. Then Lordship would see the order, that is page 33, the order, affirmation order of my service, my service affirmation order. Now, gradation list, Lordship kindly see page 34. Page 34, here, Mira Suikia's serial number is 34. Page 34 kindly see. Here, Mira Suikia's page 30, serial number 34, page 36. So in this manner, Lordship would see, no, my name is not there, madam. That is my grievance. Two 2018. But we were appointed in the year 2091, we were appointed. So the graduation list of 2018, on that day, were the ward sister or ward tutor. Their list is there. But here my name is not there because I was not promoted. Neither as ward in charge, nor as ward sister, nor as sister tutor, or PHN tutor, etc. So on that day, a list was prepared where Mira Suikia's name is there. My name is not there because I was not promoted. So my simple prayer, it is a very simple case, my lord. Lordship is our when the persons are appointed on the same day. Regarding serial number 2, yes, that is that I have. Operative portion may be seen at page 8, my lord. My lord, may see page 7 of that judgment. Here, from para 4, some discussions have been made. Sri Nayar, the learned senior counsel, submits that the projection itself is incorrect as the graduation list in question is in the cadre of ward sister in charge, sister tutor, and not of the feeder cadre, namely staff nurse. Sri Soigia learned counsel for the opposite parties, writ petitioners, have submitted that it is only on publication of the provisional graduation list that I have no idea. But on the basis of this, the promotions have been made to several persons, including Mira Suikia, etc. Yes. And it's 3069, but we were asked in 2940. Kindly, your lordship's earlier order, we were asked about the IA number 1600 in WBC number 2940. Yes, that is also there. In that, in the order sheet, that is also there. 3069 or that is true. But we were actually to the IA. The revision, yes, sir, and disposition. But factually, my lord, it is factually, my lord, we need to, but we have, Supreme Court has no judgment that when juniors.
Yes.
Lordship, then it may kindly be taken at 2 p.m. I will produce both the orders. Because I have been deprived from promotion since long.
Thursday, Lordship. Yes.
Three 3069 as well as 2940. Both the orders, final order. Both the pilot? Yes. Yes. I will be. On Thursday.
May I please, Elder? Matter relates to the pension as well as other retirement benefit and some area salaries also. In this case, there is no dispute regarding the tenure of the service of petitioner as well as retirement, nothing Lordship. Just since 2020 petitioner was retired from service Lordship, 30th September 2020, but till date they have not released the pension as well as other retirement benefits and some area salary. Lordship, this is my case in this case. In excerpt 1 page 17, Lordship, this is the appointment, initial appointment order of the petitioner. Lordship. Respondent number, we also filed affidavit in opposition. He is stated regarding the area salary that there is in the head account, there is no budget. But regarding the pension as well as other benefit, they have nothing, Lordship, nothing said in the affidavit opposition also.
Yes.
Since 2020, petitioner Lordship not getting his pension, is suffering from various. Respondent number five, Lordship. Respondent number five, Lordship. District Commissioner, Lordship.
District Commissioner, Lordship, thereafter, one updated status is that on 24th September, Lordship, one letter has been written to the District Commissioner by the joint LR of the Government of Assam. Lordship, regarding seeking detailed statement of area salary along with the non-royal certificate. So on this, Lordship, I need to take an instruction, Lordship, whether this has been received or
Respondent authority, Lordship, pursuing regarding the only area salary, but they are silent regarding his pension and other retirement will benefit, Lordship. Totally silent regarding the pension, Lordship. Only they have said regarding the area salary, where they have every document they have annexed, Lordship. What amount pending regarding area salary, all certificates, everything is there, Lordship, they have annexed. In details, page. Nothing, Lordship. He served 40 years in the department, Lordship. Only district commissioner not forwarding his pension papers. This is the main issue, Lordship. Page, Lordship, kindly see page 18. Page 17, this is the initial appointment order, Lordship. Page 16, January 1978, petitioner was initially appointed in the appointed temporary as a peon attached to the government pleader, Deputy Commissioner Court, Haflong. Thereafter, Lordship, page 19, his service was confirmed. Page 19 in exact 2, along with others grade employee in the establishment, Lordship. Serial number 7, this is the petitioner, Lordship.
Lordship, then the because
Nothing dispute, only they have not released the pension, Lordship. Petitioner several occasions, more than 50 times he has approached before the respondent authorities, Lordship. Not forwarding the pension paper, not releasing the area salary, nothing, Lordship. No dispute, nothing. Any representation we have annexed, Lordship, in this petition. Earlier also in their 2021 petitioner approached this honorable court regarding his area salary. That time, Lordship, this honorable court without deciding the merits and issue of this case, Lordship, just directed to the respondent authority to dispose his representation, Lordship. This is also not disposed till date, Lordship. In annexure 29, we have annexed the earlier order of this honorable court, Lordship. No recovery, no suspension, nothing in his service life, service career, Lordship.
in our affidavit, one statement is there, Lordship, regarding this. He was drawing salary under the head of account so and so, which had already been handed over to the Chief Judicial Magistrate Haflong, and the online salary details are no longer available with this office. Uh, 47, Lordship. The affidavit in opposition filed in paragraph 4, but the page is 47, Lordship. Also in reply to the letter of Judicial Department Dispur, it was informed by the District Commissioner Dima Hassa by letter number so-and-so dated 6/12/22 that certificate as sought by the department for release of salary could not be issued by this office as the incumbent so-and-so has been drawing his salary under the head of account so-and-so, which had already been handed over to the Chief Judicial Magistrate Haflong, and the online salaries details are no longer available with this office.
Judicial Department, Lordship, forwarding next para, Lordship, a letter from the joint LR.
No, this is okay, Lordship. Is the head of account who is the Chief Judicial Magistrate, Lordship. So reply from them also is, from this institution is also required, I think, Lordship, to sort out this. It is not that we are just saying that this will not be possible, Lordship. তোমালোকে কিবা লিখাছে? Performer typing here ধৰিলে নহ'ব। নাই, ক'ত performer? কি CGM necessary party না নেকি? Don't.
Originally, this establishment, both establishment was one establishment. CGM and DC is half.
There is complete separate. Office may be certain, but the establishment are different. You cannot feel that CGM and district commission are the same. Whatever it be, whatever it be. These are the two heads, no? This one is the administrative side, another the judicial side. I think, Lordship, response from the Chief Judicial Magistrate is also required, Lordship. Bima Hassan standing counsel, they are not repairing. Bima Hassan, maybe. Bima Hassan.
Therefore, to affidavit in opposition, Lordship, page 71, last page 48, Lordship. The district commissioner said that if area salary is sanctioned from the current year salary budget, then it will not hamper the drawal of regular salary of officers and staff of the current year from the district commissioner Bima Hassan. He also agreed, Lordship, to release the salary, Lordship. Pension as well as area salary, other benefit, retirement benefit, nothing has been released, Lordship. Not a single penny is received by the petitioner, Lordship, till date, since 2020.
Lordship, till now we have been here as the performer party because the appointing authority is the GSM. Lordship, if any instructions are required, Lordship will kindly direct the petitioner to serve us the copy as well, because we
We
have
have
not
already
received.
served, Lordship.
No,
We
Your
are
Lordship.
party in the writ petition. We
We
have
are the
rec-
party. Yes, Your Lordship, but we have not received any copy. And also there was an order where it was directed that the petitioners were supposed to tell the court how the CJM is the necessary party, Your Lordship. But orders are so given.
District Commissioner showing
You can
that
check
everything
online.
depend upon the CGM, Lordship. There is a question. Now they are putting the question that how I will make party in the CGM in this case. Lordship.
Since we are not the appointing authority, so we were kept as the performer party in this matter. Yes. Lordship, I am for respondent number 4, CJM, Lordship. Yes, Your Lordship.
Judicial Department is there, Lordship. Respondent number 1, Lordship.
Yes, Lordship, I am representing the judicial
Respondent number
department,
1,
Lordship.
Judicial Department.
Respondent number 4, Your Lordship, HK Das, my senior. I'm on behalf of Mr. HK Das, Lordship. Lordship, he is in CAT actually. Lordship, no, we had intimated.
I will give Lordship. Earlier we have already served. He once occasion he also appeared in this case, Lordship, Mr. Escobar.
Intimated, Your Lordship, but we have not.
I will
received
serve
the
Lordship again, Lordship, not this. Short date is.
Yes, your lordship. Lordship, data is regarding regularization of service, lordship. Regularization of service, lordship. The petitioner is a Safaricom lordship. And he has been working from 1/7 to 1989, lordship. And lordship, on 19/8/2023, petitioner has filed a representation before the concerned authority, lordship. Kindly give direction to dispose the annexer sheets, lordship, page 25. Lordship. Lordship. Lordship, I file reply, lordship. Give to extent.
Lordship, I have a primary objection on the maintainability of this petition on grounds of
Here and seek time, lordship, for filing the affidavit, lordship.
Lordship, Joint Lordship Secretary, my lord, recently issued one notification, my lord. There, my lord, it is clearly mentioned that the Anganwadi helper to be eligible for a promotion under the scheme shall not be above 50 years age at the time of consideration of her case for promotion, my lord. Now, my lord, I am already crossing, my lord, 50 years, my lord, on 31/12, 2025, my lord, I will cross the age of 50 years, my lord. So it is urgent for consideration, my lord. Age of 50 years, my lord, on 31st December 2025, my lord. Lordship, I was initially engaged as Anganwadi helper in the year 2007, my lord, and since 2020, my lord, I am rendering additional duties as Anganwadi helper worker, my lord. I was entitled to promotion as an Anganwadi helper, my lord. I have already made application in the year 2020, my lord. That application has not been considered till date, my lord. Application for promotion of the promotion to the post of a Anganwadi worker, my lord, as per notification dated 4/3/2013, my lord. My date of birth is, my lord, 31/12/1975, my lord. No, my lord. Till
Lordship, it is not even considered, no vacant post, nothing is there, lordship. Lordship,
my lord.
then
Yes, ma'am.
yes, copy আছে।
Lordship, page 12, my lord. Annexure 1. Uh, 3112.
In your lordship, I shall, 2 weeks it not be possible, lordship. 3 weeks.
Most obliged.
Obliged, your lordship.
Not item 11, my lord, Gautam Goswami, my lord, he will be appearing, my lord. He is on leg in court number 1. After some time, my lord, I am saying.
A small issue with regard to section 11, man. Already it has been dealt with. Well, appointment of an arbitrator, my lord. Arising out of the same, but my lord, already one tribunal has been formulated, my lord. That is at page 266, my lord. Yes, ma'am. My lord.
Supplemental list for admission item 17.
Please, the lord.
Lordship, I have received instructions here, Lordship. I need some time to file my affidavit. Also, the records are not available right now, Lordship. So some time may be granted. So I can produce both the affidavit and the records, Lordship. Lordship, I'll get the records then, Lordship. Yes. Yes, Lordship.
Yes,
That is disposed of.
Yes, lord.
Obliged.
I'll upload it.
18.
On the last occasion, my lord, the respondents were directed to place the inquiry report.
As per the last order dated 15/10/2025, Miss Lordship, Miss A for Standing Council of NHM, they produced a record inquiry report undertaken by the ADC, which led to the termination of the repetition today. So Lordship, I think Standing Council NHM should be here, Lordship, to produce the record again for the perusal of the court. Also, may take up the matter after some time.
Typing item, please.
Lordship, even my assisting counsel is also not here, but on the limited point Lordship has raised that there is an interim order. Lords. Yes, Lordship. So that point is very clear, Lordship. I have gone through some of the judgments of the Supreme Court. Any interim order, whatever order is passed, is tentative in nature, and that will not affect the final hearing. I have gone through all the judgments. I will place it also. So, and the prayer in the judge was to just to stay the impugned order. That was the prayer recorded in first or second paragraph. And the Honorable Court finally said that the order is illegal. That is the crux Lordship, what Lordship is trying to indicate. But if we look at the overall scheme of things in judicial proceedings, Lordship, the Supreme Court from a case of from Assam very categorically said that whatever order is passed in the interim or in the injunction or in the interim, these are not final opinion of the court. These are tentative in nature. The final order, final opinion will be only by the final hearing judgment. The law is well settled to that point. My assisting, let the matter be taken up day after tomorrow, Lordship. Because if I get engaged in court number 1 in item 7, then whole day will go. I do not want to keep Lordship waiting. That's why I was waiting. But my assisting counsel Dipankar Nath, he is also engaged in court number 1. Day after tomorrow, if it is not inconvenient. Or maybe tomorrow also, because we will hardly take 10 minutes. File for judgment person. Where we got the books and everything. Tomorrow. Lordship. 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 Yes, deeply obliged, Lordship. That is the only query, isn't it, Lord? Highly obliged.
I think 18.
Imdad Chand. Imdad Chand.
Imdad Chand.
Inquiry report of what?
Inquiry report and the allegations. That is inquiry report and some communications and office notes are there.
This appears to be a separate inquiry, my lord. Page 34, it reflects an inquiry conducted by the ADC. Imdad Chand.
No, they have handed over today only, my lord. So yes, my lord.
Keyboard, lordship. Been taken up on Friday next week. 14 minutes. 14. All no 17, let it be on 17. Let it be on 17.
Time being motion, passing number 16. For hearing assemble.
Statement of objects and reasons. So I had emailed the statement of objects and reasons on the last date. Lordship? I had taken the email ID from the court master and internal page 882 of the Gazette notification. Lordship, the entire Gazette has been emailed.
Lordship, this is just one of the pages of the entire email. Lordship. This was the
Yes, I
bill.
have informed already.
This was the bill, and along with the bill, the statement of objects and reasons is there. Lordship.
Lordship, may kindly take it day after tomorrow. Because some health issues are there. Lordship. Then on Tuesday, Lordship. 18th. Lordship.
Pleasure.
Okay. Lordship, in this case, your Lordship directed on 4/6/25 to furnish the requirement of 12 subsection 1 that declaration, whether that has been furnished or not. Furnished yet? 4/6/25. Lordship, may kindly pay this order dated 4/6/25. By the arbitrator? Mamoni Bora.
Maybe Momita Bora.
Momita Bora.
Momita
sorry.
Bora. Sir, declaration was not issued. There is a behind reason is that because they have, my learned friend has already enclosed one of the award passed by that same Momita Bora. Then again they say on that, until that time they never said that there is any doubt. Lordship. Sir, Lordship, my submission on already on page number 14 of my affidavit, I have mentioned that this whatever my application file, that is not maintainable. That is a lot of Supreme Court decision I have cited. Yes, sir, review not applicable, not read. Or one thing I'll say, sir, this again last time also they filed writ petition.
Lordship, the appointment of the substitute arbitrator, Lord, by which Miss Mamita Bora was appointed as the Lordship. Lordship, page 10. Lordship, can you allow me to place the facts, Lordship? Lordship, in this case, one initially late Colonel Manoranjan Goswami was appointed as the arbitrator. Now, since Momita Bora was the secretary of that arbitral tribunal, it was not known. So when, after the expiry of Mr. Colonel Manoranjan Goswami, the OP filed a petition for substitution. And during the course of hearing, he suggested the name. Now, it was not known to me, there was, because the respondent has not received any notice. Physical notice, Lordship. So I was present there, I neither consent nor protested, thinking what will be the humps in some arbitrable functions really. But when later came to know that she is already secretary of that earlier tribunal, she passed an arbitration award in our, where the work value was 25 lakhs and the award was more than 1 crore. She was even appearing in case in the very same division in some writ petition also. So that is a apprehension of genuine apprehension, Lordship. Then we asked her to give a declaration that we filed a petition before her. No, there, Lordship, in that case.
Agreed,
let
agreed
me
is
finish,
last,
let
that's
me
why,
finish. Lordship, I will cite something, Supreme Court decision where Supreme Court says there has to be written instruction from the client. There has to be written instruction from the client for giving a consent. Means if the council gives a consent, that cannot unless there is a written consent from the party. Lordship. No, my state, Lordship, our stand is clear in paragraph, Lordship. Para 4, Lordship, para 4. That he has no objection if a new arbitrator is appointed by this court, Lordship.
Proposed action.
Lordship. Consent and absence of any impediment. That impediment, Lordship, she has to file a declaration. That is mandatory, Lordship.
Sir, Lordship, I'm having separate things actually. My separate thing for which I have already made
My
a
question
level.
was in respect of a new arbitrator only.
Lordship, already present position the arbitrator is, we have filed the claim, they have responded, the refunded file on hearing has already been done within 7.5 months. Only one hearing was left for the award, then they come before this court. Now my submission is whatever the section they are saying, section 12(5), that is not applicable to me. That I'm coming that way. Because, sir, I have mentioned over here also, because whatever the because my contract was of 2008 and 9. And therefore the amendment is to come on 2015. Prior to that, or we have already asked for whatever it is, Lordship, we have, as per section 20, we have to see when first invocation of arbitration. That is why in 2010. Lordship, this is 5 is, I'm not talking about 5, Lordship. I'm talking about if 5 is not applicable because amendment, if you kindly, Lordship, kindly see, amendment 20, section 26 says amendment 26. 26th of 2015 amendments. That is separate amendment mentioned in this book also. I'm having with me. Yes, right, sir. But my invocation of arbitration earlier before the chief engineer, and this code was 2010. That is at that time section 5 is not there, Lordship. So, Lordship, I want to highlight on the section 20 of the Amendment Act 2015, section 26. I'm having this book, and Lordship, one thing, that I have submitted the Honorable Supreme Court judgment. Kindly have a see on page number 16 or my application, Lordship. Affidavit. Page number 16. I have mentioned over here also in detail. Supreme Court, Messrs. Sri Vishnu Construction Company versus engineering chief, they say, in which they have already mentioned that section 12(1) of the Arbitration Conciliation Act 1996 introduced by Amendment Act 2015 and not applicable to this case as the matter governed prior to the amendment of 2015, that is pertains to 2008 and 9, and as in Supreme Court so and so. It is not applicable to me, Ross. I have already submitted Supreme Court judgment in the record. A judgment is all filed, Lordship. I have already submitted before. The Messrs. Vishnu 2023 8 SCC. Lordship, I am having the other publication judgment actually. Coming to paragraph 27. In my case, it is 27, Lordship. We are also of the view that it is starting from it.
Lordship, the question is, Lordship, question is here whether the Lordship can review or not in an arbitration appointed by Lordship. In that case, I am relying on a Supreme Court case, Lordship. 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 No, Lordship, section 12.5 start with a non-extensive clause, Lordship. I'm not done for that, sorry, Lordship. I've not done for that judgment, Lordship.
You can see here also. It is 26 amendment. Any amendment में जाइए amendment ये नहीं है और पिछोड़ से ये 26 amendment है ये amendment act नहीं है amendment है starting में जाइए
ठीक होता है ये
है, बोलो सुनिए
कौन सा section email हुआ है?
26.
ये तो
आप ले लो, ले लो.
Lordship.
Lordship.
Marat is on legs at, I think, on court number 1. Let him be fixed on next week, Marat. On 19th, Marat, if the court comes, or 20.
Much obliged. He's in links.
I got 17th, I have some difficulty. 19th or 20th? Grateful.
He's in links.
Fast.
I'm under court alone. Yes, Lordship, I'll convey to you.
Grateful.
Much obliged.
I think 14.
I guess, Lordship.
In hearing.
Yes,
We were the petitioner, Lordship, my senior, he has just gone out. If it can be listed in some time from now. 15 hearing.
15.
Yeah.
Please check the cause list.
It's 15 hearing, C Chaudhary.
You said 14. Already got.
We are on the daily list.
14. Because for Thakur. Okay.
Yes.
If it can be just listed in some time from now, like serious. Human error.
Your printing council was mentally somewhere else.
It was.
Did not appear. We passport. Now the other side council, we can. Request our presence, we can take up the matter.
Only for a short while I went out, my lordship.
Lordship, I was under the wrong impression. It is 15. It was apparently. I was right in front. My apologies.
The other side council. There we go.
So here in this, your lordship has asked pertaining to that sick leave to clarify on that point on the last occasion. Here in this, your lordship, my grievance is very simple. Only the thing is, when I was on a sanction leave, when I went back to home, I met with an accident for which I was been hospitalized immediately based on the urgency, which I have intimated the department. But those intimations were never been considered, and I was been treated as an ex-party, and thereafter I was straightly been removed from the service without giving an opportunity. In that regard, your lordship, RPF rule.
Lordship,
Yes.
not during the statutory period, but after filing this writ petition, subsequently they had submitted one representation that was considered and rejected, but not actual appeal. As per
But so far as this entire matter is concerned, if your lordship may just see once rule 153.9 of RPF rules. RPF rules. RPF rules, if I may read, if your lordship permits, 153.9. It says, if the enrolled member fails to turn up on the day fixed for the start of inquiry and no reasonable excuse is offered for not being present on the fixed time and day, the inquiry officer may commence the inquiry ex parte. So far as the reasonable excuse is concerned, we have already intimated the same. Now, if your lordship may again just see the rule 105 through letters. Then if your lordship may again see rule 105.2. The 105.2 is very interesting. It says, leave shall not be granted to a member of the force whose conduct is under inquiry except when it is required for hospitalization purpose or in extreme emergent cases. So that says that no leave shall be granted, but I was on the sanction leave. And prior to grant of the sanction leave, the inquiry was already, I was under inquiry. What we are praying before your lordship is, your lordship, just your lordship may just see, it's in the Hindi typing. Page number 69. Ha, 68 is the type copy. This was of 3-1. My sanction leave was still 5.
How will we send it? How will you indicate it?
That is not clear, but we have intimated the same, and that is reflected on their record, on their entire proceedings record. On the last occasion, your lordship has asked to produce the entire record of the proceedings. On the last occasion, the other side has confirmed that they have received, and it is also there in page number. Your lordship may just see in the chronological order of annexure 2. From annexure 2. This is the first show cause notice, including statement of imputations. Then this is the annexure 3, page 39 is the memorandum. And this is the speaking order is at page annexure 13, page 85. Recorded as an inquiry report. Report to 9. No, your lordship. I do speaking order. Removal a second. Inquiry report 9. Report 9. মানে just on the basis of a defense statement to vote for a piece of a not appear on an expert speaking order. Inquiry হয় না ভালো
It's a very big one because two proceedings are there, that is why. Inquiry report is here, lordship, it's in Hindi. Yes, lordship, it's big one, big one.
Yes, no issues.
একটু দিদি
Deeply obliged.
I will separately give the inquiry report, xerox copy of the other file I will provide on that date. If necessary, lordship may go through or.
Query and the positions during necessary.
Depositions are here in along with the inquiry report, yes. In fact, in case. Yes. In fact, we also don't have that inquiry report. If a copy may be given after translation. Yes, yes.
I think 20.
May it please your lordships. Lordships, this matter is basically an advertisement was issued by the CISF for appointment of Constable Fire on 29/1/2022. In pursuance of the said advertisement, the petitioner had submitted his application form on 31/1/2022. The recruitment notice is annexed at Annexure 3. Now, Lordship, subsequently, the petitioner got arrested in connection with a criminal case in Shillong. That is other. Lordship,
complete.
pleadings are complete, Lordship. No, Lordship, it's not required. Lordship, because the child, he is not being allowed to be to go for training in the CISF for the post of Constable FIR. The boy, the petitioner, sorry, Lordship.
Jawan.
He's Constable FIR and he has been given provisional appointment. But in spite of submission of the quashing order passed by the Honorable High Court of Meghalaya, the Sadar PS case number, the FIR has been quashed against the petitioner, but he's not been allowed to join the post or go for training. And the only ground is the respondents are constantly demanding the charge sheet and the final order passed by the trial court. Now, Lordship, when the High Court has... Yes, Lordship, we have submitted the order of the High Court. Lordship, the order is at page 17. Annexure 2. There were 2 criminal petitions, and in criminal petition number 7 of 2022, the instant petitioner was the petitioner, and the FIR has already been quashed against him. But in spite of that, the respondents are not allowing the petitioner to... Page 17, Lordship. 17, Annexure 2. 16, Lordship, after when the respondents were not permitting the petitioner to join the post, the petitioner had approached the Honorable High Court of Meghalaya to allow him to join. But since he is a permanent resident of Kachar, Assam, so we had to withdraw the writ petition, and subsequently we have filed the instant writ petition before this Honorable Court. He has been recruited as Constable Fire in the CISF. The provisional appointment order is at page number 46. The petitioner himself. Lordship, because we had to withdraw from the Meghalaya High Court, reason being the petitioner is a permanent resident of Kachar, Assam. Lordship, there are 2 proceedings. The first proceeding was the criminal petition, which was disposed of by judgment dated 22/8/2022. Yes, Lordship. That is why judgment dated 22/8/2022. Subsequent to that, the petitioner had been submitting letters for requesting the respondents to allow him to join the training. But the respondents, Lordship. No, Lordship. Writ petition is the second proceeding. Criminal petition was allowed. Yes, Lordship. After the criminal petition was allowed, the petitioner submitted an application for joining on 29/12/2023 that the FIR has been quashed by the Honorable High Court of Meghalaya. But the respondents did not allow him to join. That is subsequent, Lordship. I'm coming to that. After the quashing of the FIR, the petitioner submitted a letter to the respondents requesting that he may be permitted to join the training as the FIR has already been quashed by the Honorable High Court of Meghalaya. But the respondents wrote a letter directing the petitioner to furnish the charge sheet and the trial court order. Now, Lordship, the question of charge sheet and trial court order does not arise because the FIR had already been quashed prior to that. So, when the respondents were not allowing the petitioner to join the training, the petitioner approached the Honorable High Court of Meghalaya for the second time by way of a writ petition, seeking a direction that the petitioner should be allowed to join the training as the FIR has already been quashed and there is no necessity to furnish the charge sheet and the trial court order. But in view of the fact that the petitioner is a permanent resident of Kachar, Assam, the Honorable High Court of Meghalaya was restraining itself from exercising jurisdiction, and as such, we withdrew the writ petition, and subsequently we have come before your lordships by way of the instant writ petition. Lordship, Meghalaya does not play any role in this particular matter because the FIR has already been quashed by the Meghalaya High Court. Lordship, the respondents herein are the officials, the different officials of the CISF, because it's the CISF which is not permitting us to join. The Union of India has been arrayed as the first respondent, the Ministry of Home Affairs, and the other 4 respondents are the CISF officers. All the respondents are being represented by Mr.
May it please your lordship. Lordship, thing is that from the month of December 2024, basically lordship in 19 standing screening committee was been constituted for examination of cases of candidates selected for appointment in various ranks in where they will be involved in criminal cases in the post. Accordingly, lordship, from 28/12/2024, the letters were being provided for the submission of final report, charge sheet, trial report, etc. So and so, and that has been continued up till March of 2025. Several letters have been provided. Letters have been served to them for providing the documents. Now, thing is that lordship, in 31st January 2025, they have written to the commandant Bezor, Rajasthan, that I, Sunil Kumar Singha so-and-so, received letter 19 standing screening committee, which is page number 113 of our affidavit in opposition, running page number 113. That so-and-so received letter from 19 standing screening committee for examination of cases. Earlier, I have submitted the judgment and order and the FIR copy with duly attested. I want to point it out that the FIR against me was quashed by the High Court of Meghalaya. I have to utter that the said case was not in trial position and my name was not in the charge sheet. The High Court of Meghalaya has been quashed my case due to falsely implicated. So in this regard, the question of FIR, charge sheet and trial court acceptance order of the case does not arise. Therefore, I have no any other documents in this case. Fine. After that, lordship, perhaps this thing has not come into their record or something, because it's a letter of 31/1/2025. After that, also 10/2/2025, then February 2025, 6/2025, the same kind of letter are being issuing for asking for final report, charge sheet and trial accepted order. Lordship will see page number 118, which is annexure number 15 of our affidavit in opposition. Here, this part was being recorded. That has come to the notice that as per guideline issued by MHA dated 1/2012 regarding considering the cases of candidates for appointment in CAPF against whom the criminal cases were registered before applying the various posts in CAPF, a standing screening committee has been considered to examine such cases. Based on the policy guidelines issued by the MHA, a checklist of documents expected from the candidates was prepared and circulated to all unit formation to facilitate the committee in examining the cases of such candidates. cases to the individual has been referred to the standing screening committee for examination in accordance with the guidelines issued by MHA, Ministry of Home Affairs. As per documents submitted by the candidate regarding his involvement in the criminal case FIR so and so, immoral trafficking was registered against 4 accused. Lordship, registered against 4 accused, including the candidate. The case was under investigation. The FIR and the related proceeding pertaining to the candidate and 1 other accused were set aside and quashed by the Honorable High Court of Meghalaya at Shillong by judgment and order to so and so. The court further directed the investigation and proceedings against the remaining accused shall continue. The case of individual was considered in the 34th sitting of the 19th standing screening committee held on 18/12/24. However, since the copy of the final report charges against the remaining accused, excluding the candidate's name and any other related order of the trial court in compliance with the Honorable High Court judgment order dated 22/8/22 were not available in the file, the same way sought for examination and finalization of candidate's case while later dated 20/12/24, but the same are still awaited. Total 4, Lordship. Total 4. 2 approached the court, the FIR and the related were set aside. The rest are still there. And this case, the standing committee is there to consider the cases of the petition of all these candidates as a whole. They are not like separately treating each case with another. Two against 2 has been cast. No, that is fine. That's why, Lordship. My prayer before your Lordship, without the interference of the High Court, it will be difficult, Lordship. If Lordship interferes and direct, I'm not this thing, Lordship. I'm not. Basically, no. Basically, I'm seeing that this is a letter that coming for the 19 district standing committee, and I can also see that, Lordship, that although the High Court has already quashed the FIR and so. As per law. So I feel that Lordship interface will be required in the case. No, understand, Lordship. My submissions are that my submissions that is that, Lordship, that there are 4 number of people and some records are is still we are required to get. So that is the only thing, Lordship, that my matter is still pending. No, technically yes, but technically, Lordship, as the FIR against the present petitioner is being quashed, they should be allowed to again join. So yes, that is, but Lordship, I cannot, in my legal opinion, I cannot write or something. There has to be a direction from the court. That's it, Lordship.
That's the only thing, Lordship.
No,
No,
prior-
Lordship,
before appeal.
prior. Prior. And in the attestation form, the petitioner had disclosed that he was detained.
Yeah. He wrote a letter.
Lordship, 7 of 2022. 7 of 2022. Might be a typographical error. The judgment provides criminal petition 7 of 2022. Page 17. Lordship, the first one is filed by the petitioner. Yes, Lordship. Achar.
Yeah.
Must worst. May I seek a lordship indulgence, madam? Subject to my learned seniors consent, but item number 14. Oh, I thought lordship is because yes, no, 14, madam. I'll seek some time because I want to bring the records. 14, 1-4. Yes, he's challenging a DP and this penalty, consequent penalty. So I will bring the records, madam.
Lord, this is a department proceeding must consider records of the record to it. Record will be easy. I have no objection, Lordship. And Lordship has exhausted the list, so I cannot make any prayer to take up the matter today itself. It's all right.
Let me bring the records,
Come.
madam. Record only basic value. Yes, ma'am, stay. Assam Agriculture University. Proceed.
H. Sharma.
All right.
I seek your lordship's indulgence with regard to item. May it please your lordship, if I may crave your lordship's indulgence. Lordship had fixed 17th of November for item number 12, but there is some personal difficulty. My senior Mr. Rahman will also be out of station and I will also be out of station. So if it could be taken up on 18th or 19th as per your lordship's convenience. 4th December. Obliged, lordship.
Yes.
Lordship, I have seen this, that whether 12-5 would be applicable or not, that may be the lordship. I'm to 13, I think. 13 question. Lordship, so far as that whether 12-5 will be applicable or not, Lordship, since the amendment came in the year 2015, Lordship. That he may be correct on that, sir. But my case is, Lordship, whether the order passed can be reviewed or not. When no notice was received by the party concerned, Lordship. So, Lordship, in that case, Lordship, I'm going to rely on Lordship. Lordship, may kindly first, it was in 2005, volume 8 SSC. 2005 volume 8 SSC, Lordship. Page 6, that SVP case, Lordship. I will rely on paragraph number 37. Volume 8 SSC, page 618.
Volume,
Uh,
618.
618.
ठीक है.
I'm relying paragraph number 37, Lordship. May I read that, Lordship? It is fundamental to our procedural jurisdiction that the right of no person shall be affected without he being heard. Para 37, Lordship. It is fundamental to our procedural jurisprudence that the right of no person shall be affected without he being heard. This necessarily imposes an obligation on the Chief Justice to issue notice to the opposite party when he is moved under Section 11 of the Act. The notice to the opposite party cannot be considered as merely an intimation to that party of the filing of the arbitration application and the passing of an administrator order, appointing an arbitrator or an arbitrator. It is really the giving of an opportunity of being heard. So, Lordship, that is important, not a mere intimation, Lordship. Lordship, again, Lordship, may come to that order, Lordship. It is only my concern is he has no obligation if a new arbitrator is appointed by this court. Whether the Momita Bora is concerned, that is not apparent from that order, Lordship. Since the earlier Lordship.
In 23, Lordship.
(21-12), that is month of December, Lordship. 21-12. And this was filed in the month of February, Lordship.
23.
There is no
23
delay
February.
as such, immense delay, Lordship. Yes, Lordship. Lordship. Lordship, let me check out, Lordship. Yes, Lordship, the filing date is 22/2023. Lordship, from the website, Lordship. May be reported, but filing date is 22/23. That is reflected in the. Lordship. But filing date is 22/23, Lordship. Lordship. There is some objections, so matter is lying, Lordship. Lordship, on the point that this instruction should come, Lordship, in written, Lordship, I am relying on another decision, Lordship. This is also a case of appointment of arbitrator, Lordship. Later, after appointment, a review was also filed, Lordship. That was rejected. Matter went up to the Supreme Court. The Honorable Supreme Court set aside both the orders. And Lordship may kindly come to paragraph 12, Lordship. May I read paragraph 12, Lordship? Mr. Sinha submitted that the counsel appearing on behalf of the appellant in the Calcutta High Court gave consent without instruction from the appellant. Be that is, the Calcutta High Court did not adjudicate the issue taken. So, Lordship, in this very same case, Lordship, consent was given by the counsel who was appearing on behalf of the party, Lordship. The matter went up to Supreme Court. Supreme Court set aside both the orders. If there is any consent, that has to be written, Lordship. Not exactly, Lordship. Lordship, but the review was there, Lordship, on the point of concession. That's true. It was on, but on matter of consent, Lordship, there has to be written. And another case, Lordship. Paragraph 29, Lordship. May I read paragraph 29, Lordship? Therefore, the BCI rules make it necessary that despite the specific legal stream of practice, seniority is the bar or designation of an advocate as a senior advocate, the ethical duty and the professional standard insofar as making concession before the court remain the same. It is expected of the lawyers to obtain necessary instruction from the client or the authorized agent before making any concession statement before the court and on behalf of a client. Then, Lordship, paragraph 30, the quotation, Lordship, may any concession made by the government pleader in the trial court cannot bind the government, as it is obviously always unsafe to rely on the wrong or erroneous or wanton concession made by the counsel appearing for the state unless it is in writing on instruction from the responsible officer. Otherwise, it would be place an undue and needless heavy burden on the public exchequer. But the same yardstick cannot be applied when the advocate. Lordship, that part may be skipped. Lordship, paragraph 32. Next, I am relying, Lordship, that it is the solemn duty of an advocate not to transgress the authority conferred him by the client. It is always better to seek appropriate instruction from the client or his authorized agent before making any concession which may directly or remotely affect the rightful legal right of the client. The advocate represents the client before the court and conduct proceeding on behalf of the client. He is the only link between the court and the client. Therefore, responsibility and honors is expected to follow the instruction of his client rather than substitute his judgment. The next paragraph is paragraph 33, Lordship. Generally, admissions of fact made by counsel is binding upon the principals so as long as they are unequivocal. Where however doubt exists as to the purported admission, the court should be wary to accept such admission until and unless the counsel or the advocate is authorized by his principal to make such admission. Furthermore, a client is not bound by a statement or admission which he or his lawyer was not authorized to make. Lawyer generally has no implied or apparent authority to make an admission or statement which would directly surrender or conclude the substantial legal rights of the client unless such an admission or statement is clearly a proper step in accomplishing the purpose for which the lawyer was employed. We hasten to add neither the client nor the court is bound by the lawyer's statement or administrative matter or matters of law or legal conclusion. Thus, according to generally accepted notions of professional responsibility, lawyers should follow the client's instructions rather than substitute their judgment for that of the client. We may add that in some cases, lawyer can make decision without consulting client, while in others, a decision is reversed for the client. It is of it was state lordship. Only parties appeared, they submitted whatever submitted before the earlier. Lordship. both the parties appeared, they submitted the, whatever submitted before the earlier arbitrator. Those are submitted again, Lordship. And thereafter, the stay order was passed. Same whatever had been submitted earlier, Lord. Before the statement, written statement, statement of claim, whatever it may be, both the parties, the same were submitted again. So Lordship,
It was not same submitted. Arbitrator instructed us to file a statement of case. Again, we have prepared the statement of case till
nothing new
that
will
day.
come out, whatever earlier was,
And
that was.
Lordship, then they have given a pleading. At the time of pleading, at least they could raise this point. Thereafter,
We submitted a application before her, Lordship. Lordship, I accompanied that both. Page 31 is the application we submitted before the arbitrator. Page 31, Lordship. 31. Additional affidavit, we're running page 31. In paragraph 2, Lordship, we make it clear that we did not receive any communication from the court. And paragraph 3, we made a request to the 31. Made a request to the arbitrator on the declaration of 2012-1. That is, of course, a matter of whether that will be applicable or not. Now, she has replied to this letter, Lordship. Page 34. And the relevant is page 35. Start from paragraph starting with further. May I read that, Lordship? Further, it is pertinent to mention that the respondent has submitted a letter dated 27 January 2023, bringing in some allegation against the arbitrator. With respect to such comments made by the respondent, though at present I would not like to make any comment on those allegations, but would like to state that instead of doing this kind of activities, the respondent should be more focused on the case and try to submit all requisite document on time before the arbitrator and contest the case in the best possible way. Also refrain from sending some same document through all means of communication. Any communication to other also should be sent to the claimant and vice versa. So instead of deciding whatever is whether our genuine apprehension, or she stated that we should continue with participating on that before arbitrator. Now, so far as Lordship, this. Lordship, well, the power of review, Lordship. I'm relying on 2019 3. Yes, Lordship. 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 31/23. Lordship. $12.5. Thereafter, further proceeding has been stayed, Lordship. Now, on the point of whether review will lie after appointment of arbitrator, Lordship, I'll be relying on 2019. Lordship. Yes, today, this week. And thereafter it had been reiterated from time to time, Lordship. It was extended, Lordship, from time to time. And Lordship, on the point of the review line, Lordship, I'll be relying on 2019 3 SCC page 203. That Municipal Corporation of Greater Mumbai versus Pratibha Industries. 11 paragraph are 8 and 11, Lordship. Eight and 11. May I read paragraph 8, Lordship? See, Ranjit Kumar Lan, Senior Counsel for the appellant, has argued before us that it is obvious that on a perusal of clause 13 and clause 22, no arbitration is provided for, and those are the only in-house procedure. You want to state that it is always inherent in a high court, being a court of record, to recall its own order, and has cited certain judgment together with High Court original side rules. According to him, the appeal under section itself was not maintained and for the next paragraph, Lordship, paragraph 11. Insofar as the High Court's jurisdiction to recall his own order is concerned, the High Courts are courts of record to set up under Article 250. That's it. So this is also arising out of a arbitrator, appointment of arbitrator, this case. So the power of review is there, Lordship. On that point, Lordship. And so far as Lordship, the consent, Lordship, there was no. And even if his Lordship consent was to appointment of arbitrator, only new arbitrator, not to that one who has been appointed, Lordship. Consent was given for appointment of new arbitrator. That is true, Lordship. But no consent was not for that Mamita Vora who has been.
Lordship, I'm sorry. Sir, my submission is whatever my learned friend submitted, that is for the new Act 12(5), and it is not applicable. So I have already placed the record. Secondly,
Only one
Lordship,
point, Lordship. On rules, section 16 says, even after submission, Lordship, I can raise that point, Lordship. That's 16(2). A plea that the arbitrator does not have jurisdiction shall have raised not later than the submission of the statement of defense. However, a party shall not be precluded from raising such a plea merely because that he has appointed or participate in the appointment of an arbitrator. He has taken before that, Lordship. Before the arbitrator was taken, that we submitted application. Thereafter, we came to this court, Lordship. We have taken that plea. And whether facts of the case, Lordship, she has been appearing against us in same division, Lordship, as an counsel, Lordship. That is my
the Honorable Supreme Court says in several judgments, if arbitrators not hear them, whatever is their matter under section 16 before the arbitrator, whatever they should have raised that. They have, but let's see, this law says no proceeding will not stop, but they can challenge under section 34 or 37. Sir, I'm coming to page 15 on my submission of the same judgment. Yes, sir.
Page 33, Lordship. Page 31. 31, Lordship. And we raised the question on the qualification of the arbitrator also, because earlier arbitrator was an engineer, and as per section 70 of the GCC, the arbitrator should be an engineer from the engineering background also. That I have annexed the relevant clause 70 at page 33, Lordship. That point was also taken before the arbitrator. By paragraph number 4. Lordship. Lordship.
Lordship, for the claim of
The
3 crore.
engineering background that has been
No,
taken,
no,
paragraph 4.
no, not at all.
Paragraph
It is,
4.
it is not required. When the chief engineer has refused to appoint arbitrator, Lordship, then only the court has appointed other than the engineer officer. That is power of the court. They can raise objection again.
The apprehension is there, and this genuine apprehension, because the way he's wanted to the particular person, Lordship, speaks for itself, Lordship.
Lordship,
Lordship, that's true, Lordship. The power of review is also there, Lordship. And it's a genuine case, Lordship. 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 That has not been answered. Let her take a fresh decision. Let her take a fresh decision on that.
Lordship, arbitrator said. Arbitrator said.
Lordship, can I take a leave, Lordship? One matter has been. Lordship. In arbitrary petition 4 of 2014. 2014. 27/1/23. Lordship. It should be 12/5. No? Yes, Lordship 12. That Lordship 12/1 is available for earlier also, Lordship. Lordship one is 2019 3 SSC, page 203. Party name is Municipal Corporation of Greater Mumbai and another versus Pratibha Industries. 19 3 SCC, page 203. Page 203. The other is 2015 7 SCC, page 373.
2015-20.
Thirty-one to 2023.
On 25th.
Lordship.
25th, no, sir, Lordship, on 25th, court may please be fixed.
No, Lordship.
25th of November.
Let it be in December, Lordship.
No, sir, no, I have to come. November, Lordship.
Quickly oblige.
Obliged, Lordship. Lordship, can we have one without signed copy so that arbitrator, we can send to arbitrator? Okay, okay, Lordship. Lordship, obliged, Lordship.
Yeah, please, Your Lordship. Item 101, Lordships. One. Earlier, 3 occasions, Your Lordship had, it was listed the part 1 hearing. Other side is the ONGC. And private parties are there also. And last occasions, I have not seen in the court, Lordships, but Mr. Senior Advocate, Mr. Jain Sayawala is engaged in the ONGC matter, Lordships. In this case, he is handling lawsuits and other. My grievance is that lawsuit ONGC issued an advertisement number 1 of 2019 for filling out 12 posts of assistant technician electronics air to level. 6 posts were meant for undeserved and 6 reserved. Out of 6, 1 SC, 2 ST and 3 OBC. And I belongs to general category lawsuits. Being eligible, I applied for the same within the zone, and thereafter, Lordship, a short list was published. My name within the consideration of 6, my serial number 5 appeared. 6 posts was reserved for general and 6 posts unreserved. My name appeared serial number 5. And thereafter, they asked me to upload the documents verification. Accordingly, I uploaded documents. I uploaded documents including my residential status certificate. Your lordship will find residential status certificate, lordships. That is the dispute only. Residential status certificate is page 59 of the writ petition. 59 of the writ petition. Fifty-nine is the type copy and 60 is the photocopy, lordships, from original. PRC. They stated that it is in respect of beneficiary record, not considered as PRC. This whole dispute is here. Yes. Purpose for education institution, whether the applicant is a permanent resident in the district, yes. Based on report of circle officer, Polgasia byte number so and so report of superintendent police, Borpeta number so and so, date 25/8. Lordship, the subsequently by email, authority informed me that I have submitted verification report, this report, it is not a PRC, that is page 61. 61, lordship will find second paragraph after dear Kinde's lordship. Please note that based on the scrutiny of the documents submitted by you, it has been observed that you have not submitted the necessary documents as mentioned in the table below. As a last chance, you are requested to submit the required document latest by 24/3/2020, 1 p.m. through return mail citing your registration number and post in the subject. Permanent residence certificates PRC shall have been issued either by Deputy Commissioner, Additional Deputy Commissioner or Subdivisional Officer Civil. PRC issued for the purpose of higher education is also acceptable. If you fail to produce the required documents by 24/3/2020, 1 p.m., your candidature shall not be considered for further selection. First one is in respect of my registration number, lordships. Registration number and verification remarks. Then thereafter, lordship, by email reply, I submitted the same residential status certificate, that is page 62, along with an authentication letter, lordships. Lordship, page 62, first paragraph, 62. Documents enclosed here given below, higher education PRC along with authentication certificate provided by the Additional Deputy Commissioner of the District Borpeta. Yours faithfully reply, lordships. An authentication letter is, your lordship will find page 64. The three persons, the lordship PRC regarding verification forwarded before the Deputy Commissioner, and three persons' name here entered, lordships, page 64. That letter issued by the Additional Deputy Commissioner, that is dated 23/3/2020, to the General Manager, Oil and Natural Gas Corporation Limited, Assam Asset, Nazira, PIN so, authentication of residential status certificate. So with reference to the subject cited, I am to inform you that the following residential status certificate were issued from the office of the Deputy Commissioner Borpeta for education purpose only. First one is the petition, lordship Soifuddin. Right side number given, lordship, that is page 59. Earlier I produced, lordship has seen. Then lordships, thereafter another short list also, lordship, published. In the final list, lordship, they published on 16/7/2020. They offered appointment 12 candidates, but my name not been considered. Then I submitted application before the authority, lordships, on representation on 71, page 71. Yes, select list, yes, lordships, first select list, lordship, will find page 66. 66 is the list, lordships. Number one from lordship will find This shortlisted category after derivation, right side lordship will find my name appeared lordships, serial number 6 lordships, Soifuddin Khan. And then thereafter the final list published, this page 68. In all the categories, not only assistant technician electronics, all the categories. In respect of my case lordship, page 69 top. 12 candidates name registration number have been given, but here my name not been appeared. Page 69. Lordship, we are in respect of assistant technician electronics. Electronics. Here 12 candidates name appear, registration number appear, lordship, but my name not considered. Then I submitted application lordship, page 71. My representation was page 71, annexure 11. Then I did not get any response. Submitted reminder also, lordships, that is page 72. Thereafter, they filed my reply against my representation, lordship, that is page 75. That is important, lordships. Page 75, that is dated Friday, August 7th and 20, issued by the ONGC lordships. May I read, lordships? Mr. Saifuddin Khan, this is in reference to your email dated so and so on above mentioned subject, addressed to asset manager Assam Asset, and your letter dated 24/7/20, addressed to GM HRIC HRRER. In this regard, may I please note that in the line with the ONGC recruitment policy, submission of PRC domicile certificate was one of the necessary conditions of the recruitment advertisement number 1/2019. Based on your confirmation of possession of required certificates, qualifications in your online application from you were considered for appearing in the computer-based written test. The first list of shortlisted candidates was published on 22/11/2019, and candidates were 10 days time to submit their documents online. Further, wherever for shortcomings were observed during the process of document verification, the candidates were intimated by telephone, email to submit the missing documents before a specified date and the time, after which their candidature was not to be considered for further selection process. During the verification process, it was observed that you have submitted the verification report in place of PRC domicile. Accordingly, as a last chance, you were intimated along with other candidates by email dated 21/3/2020 to submit your PRC on or before 24/3/2020, after which your candidature was not to be considered. In response to the said email, you once again submitted the same verification report along with a covering letter from the ADC Borpeta stating that the residential status certificate referring to the verification report as residential status certificates were issued to 3 candidates as mentioned therein, instead of submitting the required document, that is PRC or domicile certificate. As you could not produce the mandatory PRC domicile certificate in spite of giving sufficient opportunity to submit the same, your candidature would not be considered for further selection process. All the candidates who are short, yes, reply also been filed, lordships. That reply, lordship, ONGC has reply filed. Since they have not considered, I approached this. Thereafter, I approached this one report with this instant petition. Initially, my read petition. Yes, affidavit filed by the ONGC also filed, lordships. And your lordship kindly see last, your lordship. Yes, last 3 affidavit, your order dated, lordships. After hearing me, lordship, on last occasions, your lordship asked the respondent number 5 and 6 to verify the regarding authentication of my PRC and regarding the format. Your lordship will find, your lordship got a page order dated 19/3/2025, Lordship will very much clear from this. Order dated 19/3, first order, Lordship 19/3/2025. Lordship got it, your Lordship. Then thereafter, after that Lordship, or prior to that Lordship 20, I'm sorry, prior to that order is 27/2/25. Twenty-seven to also Lordships 25. And last order is 34/25. Respondents stand Lordship, the roll number 5 and 6 stands taken in affidavit
Page 3.
380, running page 388, Lordship. Their affidavit start from page number 386 from respondent 5 and 6, Deputy Commissioner's Office, Lordships. Respondent 5 and 6, after Lordship's order, the respondent and submitted affidavit, Lordship also. And ONGC only disputing is a verification report. And nothing else, other respondents also, Lordship. 5 and 6, Lordship respondents, 5 is the Deputy Commissioner Borpeta, and 6 the additional Deputy Commissioner Borpeta. In response to your Lordship's order, they submitted affidavit also. Page 386 start from. And relevant paragraph 4 and 5, Lordship, and they have annexed some of the residence status certificates of other persons also. Paragraph 4, Lordship, that it will be pertinent to mention here that although PRC certificates are issued in other districts of Assam in offline mode, there is no sample of PRC available in respect of the district of Borpeta during the year 2008. Only the aforesaid samples of residence status certificate are available in respect of district of Borpeta. But the procedure followed for issuance of PRC, that is after due verification of concerned revenue circle officer and office of superintendent of police, was carried out in offline mode for residential status certificate. Lordships, keep it as part out and list the matter part 1. Otherwise, other